Welcome, everybody. As Rory said, this is part of the ISBL Expert Talk series, and what we're looking at today are the contractual issues for schools recovering from COVID and preparing for life after Brexit. So lucky you to get both hot topics of the last few years, COVID and Brexit, in one seminar. So what we're going to be looking at today, if we look at what's coming up, I'm going to take us through the first part, which is reviewing current contracts, important clauses, and within that we'll be looking at force majeure, unplanned closures and review clauses, and then looking at commercial and practical lessons from the lockdown, essentially looking at what sort of things we've come across, the tips and tricks that we've found have worked quite well, and looking forward what is useful to look at for the future, for whatever we know is coming up. And after I've done that, Stephanie will work on the procurement angle sides of things. We'll be looking at various aspects of the procurement rules and looking at forthcoming changes to the regime as the future unfolds. I'm a partner in the VWV commercial team. I work almost exclusively with academies and academy trusts on the contractual and commercial side of things, as well as wider experience and advice. And Stephanie is a partner with particular expertise in procurement. So we'll start off by looking at contractual implications and lessons. And to start with, the very first thing, we'll be looking at reviewing current contracts. And of course, the number one reason for this, and the number one aspect of why this is important at this stage, is as we've seen happening in the north already, as we've seen maybe happening in various other regions, lockdowns will happen again, whether they extend to schools or not, whether they extend to key workers who may or may not be involved in schoolwork, will be flexible. But the important thing is to be as ready as possible so that schools can be in the best position when and if these things happen again. So just to check whether we are all engaged and ready to take part, the first thing I'd like to do is have a little poll, which is about how many of you out there have reviewed your current contracts over the last 6 months. And these are reasonably material contracts, but ones where there hasn't been an issue. So not ones where you've been forced to look at it, but for those ones that have just carried on running in the backgrounds, how many of you have actually reviewed your current contracts given the current circumstances? So if you can answer that now, that would be very helpful. Thank you. And I think that should hopefully have given you enough time. So if Rory can work the magic, we'll see the results. Well, you don't get much more of an even split than that. So 50-50, exactly on the money. 50% of you have reviewed your contracts, 50 haven't. Now that's interesting to note because it could well be because there's been so much focus on the ones that have been causing issues and problems. But I would certainly, from our experience, say that the quicker and the easier you can do this, the more work that you do in advance, the prevention better than cure idea is better. And particularly when you are taking on a new academy, if a new academy is joining your academy trust, then clearly that will come with a suite of contracts that you haven't personally been involved with before. So if we move on to the next slide, it is about being prepared. It's about understanding how they operate and how they will deal with particular issues, obviously COVID and lockdown being the most important, but there are of course the other issues and the way that they operate and how they will work with your other contracts. What we will look at next is certain key areas that are important to focus on, and if you are pushed for time, the 3 most important areas to immediately focus on in a contract to understand the implications. But one of the things that you will get bored of, because I will repeat it several times during this event, is about communication. And we have found that whatever the commercial position, whatever the contractual issue, early and frequent communication with contractors is the key to making contracts work in practice. And of course, as lawyers, we tend to focus on the theory and focus on the written word. But the most important thing is understanding how your relationship with the contractors work. And the only way that improves is with direct communication. So if we now look at the important clauses, some of you may have attended an event we did with ISBL again some months ago, which focused very much on force majeure. Don't worry if you didn't. I'll cover it now and understand its relevance and importance. We'll also look at unplanned closures. Now, a lot of what we have focused on, particularly over the last 6 months with academy trusts and schools in general, have been catering contracts. The points that we discuss now will be relevant to all contracts, but catering contracts have been by far and away the biggest source of interest. We'll also look at review clauses and the fact they can be a good thing, the fact they can be a bad thing. So first of all, looking at and considering force majeure. Now, the important thing which is there to understand is that without a force majeure clause, there is no concept of force majeure. There is no legislation that implies a force majeure term, and therefore, if the contract doesn't say anything about force majeure, then it simply is not relevant and won't apply. And however strong the situation, however much of a lockdown there is, the parties will continue to be obliged to carry out their obligations. So what that means is that how the contract drafts and how it sets out how force majeure works is key. It's the only thing that matters. And the first and most important thing is what actually constitutes a force majeure event. Some definitions are very restricted. They list things out specifically, and only things that fall into those categories constitute a force majeure event. Others take a more wide definition and refer to anything outside of a party's reasonable control. So clearly, in the current circumstances, we've seen all sorts of force majeure clauses, good, bad, and indifferent. But the number one thing that you look for is whether they contain the word pandemic. If they contain the word pandemic, then we're fairly clear as to what's involved. Otherwise, it's about looking and understanding that. The other important and key thing that we found is some clauses are drafted on the basis that this force majeure event has to prevent performance of obligations, whereas some are far lighter touch and refer to it affecting performance. And clearly what we have here is situations where schools may be closed. If schools are closed and a contractor is unable to get into school to perform their obligations, then that is clear. That is not only affected, it's prevented. But there could be a situation where a contractor theoretically could come into school. It would be immensely difficult. It would be time consuming. It would be costly, but they are not prevented from coming into school. So it's important to understand whether that is a prevention or an affection situation. Other important points in a force majeure clause, there may be a minimum period of qualification. It may set out that the situation has to be in place for a week, 2 weeks before the relaxation rules come in. But almost always, there is a notification obligation. And the relief granted by a force majeure clause will not apply unless or until the party affected serves a notice on the other party explaining what is happening, explaining that they are suffering a force majeure event, setting out the details, setting out why it affects their ability to perform, how long they believe it's going to perform, and so on. The contents of that will vary from contract to contract. And once that notice is served, what are the implications? Does it immediately relieve a party from all of their obligations or only some of them? And when that party is relieved, does that apply just to them or does it apply to both parties? And finally, a force majeure event will often give rise to a termination trigger. This is often stated to apply if the force majeure event goes on for a set period of time. And it could be that it has gone on for a set period of time, or that it is likely to go on for a set period of time. And clearly, in the current circumstances, if you have a lockdown that is in place and has been said to go forward for a particular length of time, the ability to terminate in advance of that time period having happened could be key, and therefore it's important to understand that. All of this goes, and again, it's something that we will continue to talk about, is that this is not just a question of managing a contract during the particular issue and the particular event in play. This is about ensuring that you as a school have contractors in place and ready to pick up as and when the event stops happening. And so one of the big issues we've been involved in is this, what's called recovering from COVID, how to pick up again contracts that have been put to one side or suspended. So moving on, one of the other clauses that we've often come across, and this particularly happens during catering contracts, is that they have terms and have clauses in there dealing with unplanned closures. And the problem that we have come across is that these clauses often were designed for and drafted on the basis of short-term ad hoc closures, the most typical example being a snow day. So a contract is expected to run every day during term, but it is recognised that from time to time, the school may close for a day, have a snow day, and therefore the contract provides for that and sets out what happens. So within catering contracts, often in a snow day situation, the school may be responsible for paying 1/190th or whatever the relevant figure is relating to term days of the salary cost of the staff. There may also be, if there is a guaranteed return, a reduction in that return on a corresponding proportion. But that was never intended simply because no one thought that this was going to happen or there was any likelihood of applying in the long term, of applying to a lockdown where schools were closed for weeks on end. And clearly that has a very different implication if you are suddenly exposed to a legal commitment to pay the salaries of the catering staff during that period that they are closed. There are also big implications there in terms of any future government programs such as furloughing. Furloughing certainly came to the rescue of a lot of contracts this lockdown. Will it apply again in the future? And if it does apply, how it will apply is going to be key. And it could be that if you are obliged to pay the costs of these of staff, they may not be able to access furloughing in the future. So we are certainly now drafting contracts on the basis of differentiating between short-term unplanned closures and long-term. And I think it's key to get that in there if you can. And if it's in there at the moment, to understand how it may work in the event of a longer lockdown. Whether the contractor can manage is a key part of this, and its impact on school budgets and operations. It's important to make sure that this is a contract that works both ways. As I said before, the only contract that works well is a contract that manages to suit both parties, and you need the contractors there to pick up the services again in the future. If we look now at relief clauses are clauses that are there to recognise that what happens in the future is not predictable, and there may well be changes. And therefore, what this allows, either at set periods, once a year or on notice, is for the parties to review the costs and obligations of how that contract is running, what may need to change, and if it is not viable, potentially allows for one or both parties to bring it to an end. Clearly, this gives flexibility. It allows you to set up a contract now, recognising that there may be changes coming ahead, and allows you to deal with those changes as they come up, as and when they come up, rather than trying to predict them in advance. The downside of that and the flip side of that coin is uncertainty. If you have a contract with a review clause in it, then you can't be guaranteed that it's going to run for as long as it works. As long as it was set up for. So if you have let a contract for 4 years, if there's a review clause in it, it simply means that the contractor may be able to bring it to an end early. Within that flexibility as to how it's drafted, references to government guidance, again, are going to be key. We've seen, and everyone, I'm sure, will have come across the procurement policy notes, the PPNs that came out and changed on a fairly daily basis as lockdown started. You need to make sure that whatever this review clause is going to cover and however it works is done in conjunction with government guidance, which hopefully, if it happens again, we will also have more guidance that is designed to assist and help schools and assist contracts continuing in place. But the one thing that I look for in a review clause is this element of control. And from your perspective, it's important that this isn't seen as a tool for a contractor to guarantee that they will always have a profitable contract. It is, in any contractual situation, a risk on the contractor when they come in that this is going to be a contract that they can manage and that they can get something out of. But you shouldn't be tied into something where if it's not working for them for any particular reason, they can cut and run. So how this is drafted and how these rights apply, particularly the rights of termination, is going to be key. So if we now look at some of the lessons and some of the commercial practical points that we've come across, to reiterate, future lockdowns are not unforeseeable. For those that took part in the previous webinar, we talked about the doctrine of frustration, which is a slightly arcane legal tool, but only applies where situations are unforeseeable. We've already had a lockdown. It's certain we're seeing lockdowns happen now. It's not unforeseeable that we have a future lockdown. And I think the leeway that a lot of people were granted, both in terms of government guidance in contracts and in terms of public-facing views, were mitigated by the fact that nobody had expected it when it happened before. I don't think there will be the same degree of latitude in the future. That's why when we looked at that poll at the start, 50% have reviewed contracts, 50% haven't. I would suggest, however unattractive it may be, that going in and reviewing your contracts is a worthwhile exercise at this stage, because that gives you the ability to have early communication and planning with your contractors. And to the extent that you can mitigate and avoid situations coming across, that's key. Which brings us to the position that we've certainly dealt with over the last 6 months, which is balancing this contractual right, the theoretical right that your lawyer will tell you that you have a right to enforce this term, or they do not have a right to ask for this money or this support. Where we found this work best is where schools and trusts understand precisely what their legal position is, but then treat that as a starting point, not an end point. And go in there to start having the discussions with their partners, with their contractors, to ensure, without putting themselves in a difficult position, that they are maintaining that relationship there. Because when lockdown ends, when we come through the difficulties that we are in now, it will be important to have a partner providing the service to you. And it's worth remembering that whenever these contracts end, we're not in the same situation as before. Bringing in a new contracting partner is going to be more difficult. The negotiations are going to be more difficult. The number of companies out there who are able to take on new contracts is much lower than before. So maintaining that relationship is important. Discuss with other schools and trusts who you know, and it's particularly if they have contracts with the same suppliers, how they're working. Are there issues with a particular supplier? Is there a solution that they found that works particularly well? One of the things we've come across is this, where schools and trusts have worked together with the contractor on the other side to come up with a solution that works over a particular area, in this case, a county. We see other likely changes in the future, and this is something that's a bit more blue sky thinking. But when it comes to other types of contracts in the future, we may see different approaches taken. The one that I'm looking forward to seeing whether it works or not is photocopying contracts. Photocopying contracts are the bane of many lawyers' lives. They're particularly difficultly drafted. They tend to be watertight. But in my experience, they've always relied on the fact that schools make photocopies. The photocopier company will guarantee and rely on the fact that there will be a certain number of photocopies made during a year, and therefore they haven't bothered to have a minimum requirement in those contracts. I do foresee that in the future there will be clauses in photocopying contracts that require a minimum number of copies to be made. If a school is shut down for a term and no one is using the machines, then the investment that the companies make is not going to be recovered. And a final push and a final comment here on catering contracts, because it is something I've done a lot of work on over the last 6 months. This is not going to be a particularly popular comment to say, but if any of you out there have catering contracts which involve investments being made by the caterer, and those investments depreciate over the lifetime of the term, and there is a clause in there, which there will be in that situation, that says if the contract ends in advance of the expected term, there would need to be a repayment of the undepreciated amount. You are in breach of the Academy's financial handbook. If you are in that position and you want to discuss it, please get in touch. It is an important thing. It's something that will become more and more dealt with by the ESFA in the future. So to summarise and to put it all together, please review your current contracts, particularly if you're an academy trust taking over academies. Understand what is coming in and particularly how those contracts will work in regards to lockdown. Focus on those key areas that I talked about. Force majeure, certainly. Unplanned closures if they're in there, and review clauses. And use this as a springboard to start communicating and planning with your contractor. They are as keen as you are to ensure that these contracts work and to ensure that there will be a continuing relationship there. And rather than wait until one or both of you are seriously in trouble, start that planning at the early stage and you will find things go much smoother in the future. I don't think there are any... Oh, we have a question in. Does the school regarding investment only apply to academies? If you are a maintained school, you don't... for those that can't see it, there's a question come in about investment, whether it only applies to academies and whether it applies to maintained schools. There are different rules that apply to maintained schools, but essentially the issue that applies here is that investment is viewed as a form of borrowing. Because essentially what you're doing is borrowing and writing that off over a period of time. So there are rules, and this actually, the reason why this came about is because I was involved in a group catering contract that involved academies and maintained schools, and it was the local authority individual responsible for the maintained schools that raised this as an issue and raised the fact that this was essentially a loan. So I do believe there are problems with maintained schools in the same way. So we can certainly discuss that more, but I'm conscious of the fact that Stephanie is ready to jump in and discuss procurement. So I'll hand you over to Stephanie.
Thanks very much, Matthew. I head up the procurement and state aid team. Matthew's talked a lot about reviewing contracts and what you need to think about from a contractual perspective, but I'm going to talk about some of the implications that you need to think about as well from a procurement perspective. The pandemic has meant that procurement teams have had to adapt, doing things very differently in a very short space of time. We've had lots of queries from procurement teams on managing procurements and suppliers during COVID. So I'll talk about the government guidance and managing procurements in the next 6 months or so. There's also been quite a lot of recent government developments on the procurement front, so I'll briefly talk about those at the end of the session. So thinking right back to March, we were talking a lot about the procurement policy notes on supplier relief that came out from Cabinet Office. Those are PPN 220 and PPN 420. I just wanted to give you a quick reminder of those principles. There was also some guidance issued for the education sector, although sadly there was rather a lag in that guidance coming out. So contracting authorities were required to identify key suppliers at risk, to pay bills promptly to help with cash flow, and to communicate with suppliers to put in place supply relief measures on a case-by-case basis. Now, it may be that some of you have put in place revised delivery dates or upfront payment in certain circumstances. Now, the guidance that was issued for the state-funded schools in their fee sector made clear that although you needed to have regard to the PPN, it was recognised that you might have additional financial and governance controls which you needed to take into account in balancing that guidance. And also, Matthew's talked about catering schemes a lot. We had lots of queries about catering contracts, but for some suppliers, there will have been government schemes such as the furlough scheme that they would have been able to take advantage of before actually coming to schools and asking for assistance. And so 420 talked about the guidance on agreeing with the supplier to exit from the agreed interventions and transition to a new sustainable operating model. Next slide, please. So what should you be doing now? Well, as Matthew said, you should hopefully be reviewing your contracts. But if you have put in place supply relief, then that is due to terminate at the end of this month. And we're not expecting any change to that guidance, given that most schools have started back under the new normal conditions, so there are not really any grounds for extension. So you should, depending upon the terms of your variation, if one was put in place, carry out any reconciliations with the supplier and claw back any advance payments. And for those 50% of you who haven't had a chance to review contracts, it's worth getting them out and thinking about what changes need to be made in the short term to make them fit for purpose. For example, it may be variations to performance levels in the contracts, but you should also be considering the longer term variations. And the notice on transitional guidance says, is it fit for purpose? Do you need to think about actually terminating it to the extent that it's possible under the contracts? For example, cleaning contracts may be significantly changed to reflect new cleaning requirements, and maybe not all facilities are being used. And the position with outside school trips, they may be very unlikely to take place next year. So query whether that's still working for you. Now, the difficulty with, or the issue for those contracts that fall above the thresholds under the procurement rules and for which a procurement process was already carried out is that modification or changes to contract can have significant procurement implications. Next slide, please. So the general principle is that if you carry out substantial modification to an existing contract which has been tendered in accordance with the rules, then it's treated as a new contract. And failure to carry out a new procurement process can lead to the variations becoming ineffective. Now, luckily, there are a number of circumstances under the procurement regulations to say that modifications are permitted. the most common one used during the first lockdown was the fact that contract variations were due to unforeseen events. But as Matthew's already alluded to, I think it's going to be much more difficult to actually rely upon that exemption now. Now, there are some other provisions which talk about additional work, services and supplies. For example, if you have had to extend your contract for a short period of time, you might need or have unforeseen or you might need some additional services to be carried on, particularly for IT contracts to be added to additional IT services to deal with remote learning to be added to contracts that might help. The other ground is that if there is a clear and unequivocal review clause in the contract, that then permits the parties to make the changes, as long as the variation is in accordance with that change. And Matthew has suggested that a review clause should certainly be put in. There's also a provision where changes are not substantial. But I just want to look quickly at the cases where you're seeking to extend the contract. So can I extend a contract without a call for competition? Well, we've talked about unforeseeability. The issue with this is that there mustn't be a change to the overall nature of the contract. So, for example, we've had a number of queries about whether the catering contracts have caused a lot of problems, whether it's possible to change the basis of a catering contract from a concession contract where the supplier takes the risk to a managed contract. And arguably that is a significant change to the overall nature of the contract. Now, in terms of extending contracts, you need to think about any changes that are reasonable and proportionate. For example, if your IT requirements have changed so much that you need to carry out a complete review of your requirements and conduct market engagement and allow for implementation, then a year-long contract is likely to be justifiable. However, it's more difficult to argue that year-long extensions, just because you've got a backlog in the procurement process, or you need to carry out another procurement process, is going to be justifiable, because unless it's a very complex procurement process, it's a question of extended contracts for 3 to 6 months. I'm aware that reduced resources in schools and academy trusts in dealing with COVID have put a lot of pressure on procurement teams and managing new procurements. So there's an awful lot to think about. I just wanted to raise some of the things that are happening if you're thinking about your new procurement pipeline. Going on to the next slide, please. So if we can do a poll, I'd be interested to see how many have used the urgency exemption for contracts in the last 6 months. Anecdotally, there's been a very high take-up of the use of the exemption. I'm just interested to see if this has been supported by our very quick and unscientific poll. Right. Okay. That's interesting. So it is quite a low. It is quite a low percentage. I think it's fairly sectoral. I did a similar poll with the HE sector a couple of weeks ago, and the number of people who'd used the urgency exemption in the HE sector was a lot higher. I just wanted to talk about the rules for urgency exemption. The rules are very narrow, but for certain types of procurement, they may still be very useful. So for example, where you've had to get new these sort of screens that you need to get in place for teaching music lessons or for distancing teachers and pupils, or where you've got to have remote learning procedures in place. So the circumstances giving rise to the need to use the exemption must have been unforeseeable. Both Cabinet Office and European Commission have acknowledged that COVID meets these requirements, but obviously the longer it goes on, that becomes more difficult to argue. There must be an extreme urgency in awarding the contract, and this is a high standard. The contracting authority has not contributed to the urgency. So again, I talked about reduced capacity is not necessarily going to help, and the other time limits cannot be complied with. Now, the procurement rules provide for accelerated use of the accelerated procedure to reduce the time periods, which can be very helpful. So with an open procedure where you invite all suppliers who are interested to submit a tender response, that should be able to be undertaken within about a month. So that's 15 days for a response plus time for evaluation in your standstill period. If you're looking at a restricted procedure, you're probably looking about 6 weeks, because you've got to allow an extra period in order to select your suppliers. If you are thinking of using the negotiated procedure, and those schools who have indicated that they've used it, you might want to think about publishing a transparency notice to minimise the risk of a contract subsequently being challenged. The reason for doing this is that, as I say, anecdotally, in some sectors, there has been increasing number of people using the the urgency exemption. And because the market is becoming much more competitive and people don't want to lose out on very valuable contracts, there's more of a tendency to complain. So, for example, there's been lots of news recently about the test and trace regime, and the government has announced that it's had to make a £2 million settlement to a UK diagnostics company in relation to its use of the urgency exemption and not following the rules properly. And also there are some MPs and an organisation called the Good Law Project who are seeking a judicial review of the government's failure to disclose information relating to £3 billion worth of coronavirus contracts that have been directly awarded. So clearly there is some risk involved in going down this route. Just talking now to some practical tips for managing new procurements on the next slide, please. Just some things I mentioned that the pandemic has made some real challenges from a procurement perspective. So some of the questions that we've had is that the requirements and assumptions have changed very significantly. Matthew talked about printing contracts. Obviously, the amount that's going to be printed from what's happened in the past is likely to be a lot less. So really think about what your requirements are going forward. And it may be that you have to make some assumptions in your tender documentation about some contracts, because it's going to be more difficult for contractors to come and visit premises. build in flexibility into the timescales and your procurement plan, because everything is taking longer. We've talked about it's very helpful to include clear, precise and unequivocal review clauses into the procurement documentation, which is going to enable you to make changes later on, if necessary, without worrying about the procurement rules. I just want to talk quickly about the right to abandon, because one of the tactics that up until probably about 18 months ago that people used if they were worried about a supplier wanting to challenge was to think about abandoning a procurement process because of the cost and administrative time in dealing with complaints and possible risk of challenge. Now, whilst the general rule is that a contracting authority has the right to abandon a procurement for good faith reasons, it doesn't automatically follow that the abandonment will exclude all liability. So there was a case of Amy versus the Highway Agency about 18 months ago. And the facts are quite interesting. So what happened was that this is a high-value tender for highway services. Amy was the unsuccessful tenderer, but missed out by less than 0.03% against the score of the preferred bidder. And Amy brought a procurement challenge alleging that there had been a manifest error in the evaluation process. And the council decided to abandon the process due to the expensive and uncertain nature of litigation. But Amy subsequently brought a challenge in relation to the decision to abandon. Now, whilst the court found that the council had acted rationally and reasonably in abandoning the tender process, it felt that Amy had been deprived of an effective remedy. So it said that Amy might have a right to damages in certain circumstances. So the point that I just wanted to mention was that even if you have got a provision saying that you exclude all liabilities and you have the right to abandon a tender, you should think about seeking legal advice if you're considering abandoning a tender as one of the options, just to make sure that you're not going to get yourself into difficulty. So I just want to spend 5 minutes now talking about forthcoming changes. So a couple of weeks ago, we had the results of the Cabinet Office consultation on social value, and to talk about forthcoming changes to procurement post-transition. Next slide, please. So social value is becoming more important and is working its way up its agenda. And I know that one of the recent themes for schools has been to carry out responsible procurement, particularly in relation to green procurement. There was a consultation 16 months ago, and this has resulted on a new procurement policy notice on social value. Now, it's slightly unclearly worded in that it is stated to apply to all contracting authorities, which will include academy, trust and maintained schools. But what it says is that a central government department, which clearly doesn't catch academy, trust and schools, will have to apply a mandatory 10% evaluation criteria for social value. Now, I think what that means is that Academy Trust and schools, maintained schools, should be thinking about including social value as part of the evaluation criteria, and what the appropriate amount of that evaluation criteria should be. Now, more helpfully, what the guidance does is to contain a document which sets out a list of social value themes, which is quite wide. So it covers the Green Agenda, it covers modern slavery, it covers mental health and well-being, it covers skills and education, and talks about some of the ways in which you can introduce social value into your tender documentation. So that actually, in terms of helpful guidance, is quite useful. So, next slide, please. End of the transition period, or I think we're supposed to call it the IP completion date, or some very peculiar technical term. In the short term, in practice, there isn't going to be much change. The main change is going to be where you publish your ODU notices. The government is launching their Find a Tender service, which I think will be live at the beginning of the year. The government have recently published some amendments just to make sure that the public contracts regulations work from a UK perspective, but most of the principles of the public procurement regime will be retained under the EU retain law principle, and the public contracts regulations will continue to apply. There was some discussion as to whether or not non-UK suppliers would have the same rights and remedies under the remedies regime as UK suppliers, but I think that the government have recently announced that the UK will accede to the government procurement agreement as from the 1st of January next year, and that requires there to be a remedies regime in place. So I don't think we'll see any changes too soon. So key points. Matthew said that you would be sick of hearing us about communication, but again, I just wanted to reinforce that point in terms of communication with suppliers and tenderers to make sure that everything is transparent and they know what's coming up. Make sure any variations are made in writing, and again, having a look to future-proof your requirements. Thank you very much, and please don't hesitate to put any questions, either Matthew or myself, arising out of the presentations. Thank you for listening to us.
Thank you, Stephanie. We've had one question that's come in, which I'm not sure if you can see it, so I'll read it out. What if the supplier hasn't passed down supplier relief to pay employees and subcontractors, and we have received complaints from employees and subcontractors and we've received complaints from employees and subcontractors. And it then says, with consideration, the parties assigned the Cabinet Office variation specimen. Well, the one part of supplier relief and the PPNs which it was always glossed over by the contractors and by the service providers was the open book requirement. And this is very clear. The procurement policy notes were clear from day one at all times. This was on the basis of relief for the contractors. This wasn't a means of guaranteeing their continuing profit. So profit is always carved out of this. But if we look specifically at the guidance notes on model interim payment terms from the Cabinet Office, it does talk in the initial guidance about how the supplier should be setting out why it requires the interim relief and what it's going to do with it. And then it says that the clauses about open book transparency allow the authority to check that the proposals that they put forward are complied with. And if we then look at the actual drafting, and if you want to look at it in more detail, obviously you can do that. But the key parts are clauses 6.5.2 and 6.5.3. And I'm happy to send this out to anyone that wants to look at it. But essentially, the supplier is obliged to put forward an interim payment proposal, which sets out the purposes for why they are looking for the relief and what they will do with it, and then makes available to the authority on request any information in order to require that they've applied those monies as set out in that proposal. And specifically, it refers to verifying and ensuring that monies intended for supplier staff performing the contract have been properly and promptly paid, and invoices submitted by the supplier's subcontractors have been paid. So the clauses themselves should contain enough of a stick to hit the supplier with if they haven't done that. And if they haven't acted in accordance with that supplier relief terms, then there is action that can be taken against them, because effectively that is a breach of contract. But it goes to the primary purpose, which, again, I'm sorry to everyone here because it essentially means more work for you. But it is about requiring the supplier to work on an open book basis when you're giving them this relief money. And therefore, it is their obligation to disclose to you how that money is being used, and for you to be satisfied that it's going to cover overheads, disbursements, staff wages, subcontractor costs, etc., and not being used to shore up company profits or even to offset losses which they're suffering on other contracts. This should be an open book basis to ensure that you are not subsidising the company. So I hope that answers the question. If anyone else has any concerns or issues about it, as I say, check the terms of the drafting. There should be sticks in there you can use to apply gently, perhaps at first, but with a bit more force if money's being paid for staff costs and so on are not being passed down. That is wrong, both morally and contractually as well. So it should be something you can do. Stephanie, did you have anything to chip in on that?
No, I'm very glad that you've managed to have a chance to have a look at the Cabinet Office, because the guidance notes do deal. One of the updates on the guidance notes deals specifically with that question.
Just had another one in, which is, interestingly enough, an issue I was talking about literally just yesterday. The question that's come in is, I reviewed a contract agreed prior to me joining the MAT, so I like the start of that. I noticed that the indemnity clause did not meet Academy's financial handbook requirements, as the contract did not cap the level of indemnity the trust had agreed to provide the supplier. Any advice on next steps? The issue here, this runs the risk of falling into the sort of lawyer's theoretical, hypothetical, nitty-gritty argument, is that the Academy's financial handbook refers to indemnities in the same section as it refers to guarantees. And to my mind, and I take a different view of this than my colleague who I was talking to, I view this as being more akin to the Academy's financial handbook stopping borrowing by other means. So in other words, if an academy sets up a subsidiary trading company, that subsidiary trading company is fine to borrow. But what can't happen is that the subsidiary trading company with no assets and no income applies to borrow £150,000, and the bank requires the Academy Trust to guarantee or indemnify the bank against a failure by that subsidiary company to repay the loan. Any contract that you as an academy enter into will have unlimited liability on it. And that unlimited liability by law applies to anything that causes personal injury or death. So the very first issue to note is that there will always be unlimited liability in any contract that you enter into. It is therefore debatable, and it's something that we discussed and agreed yesterday we were going to raise directly with the ESFA, as to whether they actually have slightly ambiguously drafted this part of the Academy's financial handbook, because I don't see any sense in having something that talks about a level of indemnity being prohibited under the financial handbook. So I'm sorry I'm not giving you a straight answer on that, but that's because there is actually disagreement and discussion going on at the moment about that very specific part of the financial handbook. So I hope that clarifies a little thing. If it has helped, it's come in as an anonymous question. If you'd like to get in touch and give me your name afterwards, I'd be more than happy to update you when we do get clarity from the ESFA, because it's something I am interested in getting them to be clear on. If anyone else is interested in that, also let me know and I shall update you. But I would think it's likely to form the basis of one of our updates at some point in the future, because it is something that attracts attention, shall we say. Were there any other questions? Any other issues? I think we've almost perfectly hit it on the hour mark, Rory. So
couldn't have timed it better. Well, thank you very much for that. It was really interesting. I'm sure everyone found it very helpful. I'm sure you don't mind me saying that if you do have any questions for either Stephanie or Matthew, they're more than happy for you to contact them. If you don't have their details, please just contact VWV Events and we'll pass on any messages or questions you may have. That takes us to 11, so that's the end of our session. But thank you very much for joining us, and hopefully see you soon. Thank you and goodbye.